Well, a very good morning to you. Thanks for your time this morning. And it seemed it's been a long road, a difficult road for those on the other side of this argument who've been trying to get the former president to court to answer to these charges. They're finally there this morning. Let's explain to South Africans exactly what the severity of these 16 charges are in relation to the more than 780 payments that were made. Let's clear that point up first. It was never 783 charges, 783 payments, but 16 charges.
That's correct, and the charges are all of a serious nature. Remember, the other person involved in these corrupt activities was Shabir Sheikh, who was formerly the Zuma family's financial advisor. He was found guilty of corruption, and he was sentenced to the minimum sentence, which is 15 years imprisonment. He did organize himself a medical parole a few years after his incarceration. But the point, as far as President Zuma, or former President Zuma, is concerned, is that he is facing extremely serious charges, and that it is likely that his punishment will be not less than the punishment of his financial advisor, Mr. Sheikh.
All right, well, speaking of Shabir Sheikh, Paul, I mean, just looking at the state narrowing down that list of witnesses, it seems, to just over 200, about 207, I think. Shabir Sheikh is not on that list, as far as we know for now. What do you read into that, being the key figure all those years ago?
I don't believe that it's necessary for Billy Downer's team to rely on the evidence of Mr. Sheikh. They, with 207 witnesses, they have plentiful evidence to sustain the charges which they have brought. It's always been the case of the prosecution service that they have a good case on the merits. The only reason why the case didn't go ahead years ago is because Mr. Zuma was able to persuade Mokotedi Mshe that he wouldn't get a fair trial. That argument has been abandoned not only by the NPA but also by Mr. Zuma's legal team. So now we're in a situation where the main issue in the case will be whether he had the necessary criminal intention in involving himself in the 783 transactions which are at the bed of the charge sheet against him.
So what does the former president actually stand to lose? What would be his future if he was found guilty in this case?
Well, if we're going to look into the crystal ball in relation to this case, the minimum sentence is 15 years, but the sentence is only imposed after the state has proved beyond a reasonable doubt that Mr. Zuma is in fact guilty on one or more or all of the charges that have been preferred against him. And while today is a great day for the rule of law in South Africa, and the notion in the Bill of Rights that we are all equal before the law is certainly a very firmly demonstrated today, it's going to be a long time before Mr. Zuma is actually asked to plead. There are going to be preliminary applications, a review of the decision to carry on with the case, litigation about who is going to be picking up the tab for Mr. Zuma's legal costs, and also a possible permanent stay application by Mr. Zuma. So I think the public of South Africa needs to appreciate that a great deal of patience is going to be required in order to get to finality in this case, but that the mere fact that the case is starting and that Mr. Zuma is in the dock for a short period this morning when the case will be postponed, the fact that that has happened suggests that the rule of law is intact and that the damage done to the National Prosecuting Authority during the Zuma years has not been so serious that it is incapable of mounting a really big prosecution of this kind.
Well, let's talk, Paul, very quickly about what this actually means for the judiciary. We know that the judiciary coming under fire in the past couple of months, even by the ANC, which appears now to be withdrawing its support and its rah-rah over Jacob Zuma, but we're not sure if that's really happening behind the scenes, though. The judiciary has its work cut out for it. How do you see the sort of balancing this case and looking at all things fairly so as not to be accused of bias when it comes to this later, having come under fire for just in recent months by President Jacob Zuma himself and the ANC, but not recently, not very recently by the ANC?
Yes, no, I think that part of the Ramaphosa spring has been the embrace of constitutionalism, and that the attacks on the judiciary, the notion of counter-revolutionary judges, as Gwedi Montashi once put it, is really way off the front of the stove. What you need to remember is that it is not the judiciary that is bringing the charges. The judiciary is there to adjudicate whether the state is able to prove beyond a reasonable doubt all of the elements of all of the charges against Mr. Zuma. And in that contest, Mr. Zuma has the opportunity to persuade the court that it is reasonably possibly true that he was not acting with criminal intent when he involved himself in this 783 4 million rand series of transactions with his financial advisor, Mr. Sheikh. And that will play out in court over many, many months, if not many, many years. And there will be appeals, and there will be further appeals, and it will be a long time before one can say that the judicial files in relation to the state versus Zuma are actually finally closed. The fact that the file is there, the fact that he is standing in the dock this morning is a triumph for the rule of law in South Africa, and it is an indication that we are in the process of putting the aberrations of the Zuma years behind us, and reverting to the standards of a constitutional democracy under the rule of law, in which the judiciary is an independent body of integrity that does its work without fear, favor, or prejudice.
Thanks very much. Accountability Now Director Paul Hoffman joining us via Skype there. Just